want to talk a little bit about perjury, because perjury is a big theme, a big issue that pertains to much of what I've been posting here over the last few days, and is particularly relevant to the case on which I am urgently seeking assistance from viewers and or readers. If you do a Google search on perjury or proving perjury, what you'll find is that the consensus is, nothing wrong with this consensus, but the consensus is that perjury is very difficult to prove. And indeed, that is what we would call a truism. It's very often extremely difficult to determine who is, if anyone, is deliberately not telling the truth when there is a conflict in testimony. It doesn't always necessarily mean, when there's a conflict in testimony, that somebody is committing perjury. In other words, that there is an intentional falsehood. But there are other times when the only conclusion you can possibly reach is that somebody is committing perjury. And then you often get from legal professionals that, well, perjury is rampant, everybody's committing perjury all the time, and what do you really want to do about it? Well, I think it should go without saying that that is an unacceptable approach to the matter. Perjury is a very serious crime. It excuse me, undermines rather dramatically the truth-finding function that we attribute to our criminal justice system, or the justice system generally. So it is facile to allow the notion that perjury is difficult to prove to become some sort of dogma where we are never willing to recognize that perjury has been committed even when it's slapping us in the face. To take the matter under consideration, what the criminal prosecution of Sefred Davis really boiled down to was essentially one question. She was accused of being the real man or the driver for an armed robbery and kidnapping. As the matter was investigated, there arose a conflict in that very fact, because one of the people who had, one of the co-defendants, or one of the three people in a position to observe, recanted his earlier statements on the matter and said, no, she was not driving the car. In fact, she was passed out in the car, but passed out, not participating. So what you have at that point on the surface is a conflict of testimonial evidence. You've got three people in a position to observe, and taking the matter collectively, you've got one version in which Sefred Davis is driving the car, awake and alert, and the other scenario is she's passed out in the car and not driving at all. Now, perhaps it goes without saying, or at least maybe it should go without saying, but for some reason it does not. That kind of conflict, coming from people who are in a position to observe, cannot be an error. In other words, absent some form of mass hallucination or delusion, it isn't possible to be mistaken about whether somebody is awake, alert, and driving the car, or on the other hand, passed out. Therefore, one or the other is an intentional falsehood. You have at least that much on the surface. Now, ordinarily, it might be very difficult to tell which of those things are true or false. But if you have a situation where some highly reliable evidence either confirms or corroborates one version as opposed to the other, you no longer have that difficulty. What you had here in the Sefred Davis matter is that after the the question of whether she was driving the car or passed out in the car became an issue. Very quickly uncovered medical records which confirmed or corroborated that she would not have been driving the car and would likely have been passed out. This is the kind of evidence that is not, it's extremely reliable. It can't be readily fabricated by anyone. It's made contemporaneous with the events, and it's made by people that have nothing to do with any of the events and no interest in it. In other words, not the police, not any of the co-defendants, not the defendant herself, not any of the lawyers involved. It's generated by a healthcare institution that is not the least bit concerned with the outcome of any litigation, but is simply doing its job and keeping a record of it. So because that's the case, the issue, now you're looking at that conflict in a completely different way, or at least you should be, because now it is clear that as between the account that says that Zephyr Davis is driving the car and that she's the wheelman, and the account that says that Zephyr Davis is passed out in the car and is not participating, as between those two accounts, you know which one is perjury and which one is, and which one is not. It is the account that said that she was driving the car. So now that you know which one's false and which one has to be intentionally false, you have a second question, which is, how did this false evidence occur, and who is engaging in providing false evidence, and why are they engaged in providing false evidence? And you go on from there, and you examine the evidence or the reported evidence that shows that she's driving the car, and lo and behold, you find that it's all generated by police, and not only generated by police, but it is evidence of a type that it's very easy for the police to basically fabricate through the use of vulnerable witnesses, either because they are charged or they are going to be charged. Then you find even more dramatic confirmation that this must be perjury, because the police involved were stupid enough to fabricate one item of evidence that was obviously a fabrication, and that would be, which I've discussed a great deal on the blog, a statement known as the Ashley Baker statement, which has a conflict with another statement given by a witness named Todd Gaddy. Because of the inadvertent conflict between the two, which the police were stupid enough to miss, you can now be as certain as you could be about any evidence-based thing, that not only is the testimonial proof or the witness statements indicating that Zephyr Davis was driving the car for the robbery, not only is that perjury, but that the police themselves were the primary instigators of putting forward this perjury that formed the basis for charging Zephyr Davis in the first place. So because that's, now you can add to that when this was all presented to a state court in New York, in other words, the appellate division, in the context of what is called a prohibition proceeding to stop the prosecution. In any case, when it was all presented, none of this was disputed. No evidence was offered by the police or by the district attorney indicating that they did not know that they were using perjury. And this is what causes a record to be made, which then presents an issue to, I hope, a federal court, so that they can look at what is, at this point, no factual dispute. There's no dispute that this is actually what had occurred. There was perjury. It was known to be perjury by the police and the prosecutors, and they just went ahead and charged somebody with a crime based on perjury anyway because they had an axe to grind or they felt like it. So in any event, now that that is known, you can go to a federal court and say, here are the facts. Does the law permit them? Does the Constitution permit them without violating someone's due process rights, to use perjury and fabricated evidence to put them in jeopardy of a criminal conviction. And that's where this question comes from. So you can have, for those of you who might have any questions, you can be very, very certain of the facts here, because A, they're pretty much indisputable, and B, they've never been disputed. So that is what forms the basis for a very important constitutional question to be answered. It is an open question at the United States Supreme Court level, and that is whether due process is violated when police and prosecutors use perjury and fabricated evidence to charge you with a crime. When we think, as I said, I think in the other videos and many times on the blog, one would think that this would be a very easy question to answer. It is, in fact, an easy question to answer, but at the United States Supreme Court level, it is an open question. And that's the importance of this. This is not simply important for, as I've indicated before, me and Sefra Davis and what has happened here to her and me. This is important for other people who might wind up in the same position. We cannot have a situation where prosecutors and police feel like they can just make up charges and put you in a bad position, and then if they terrorize you into a guilty plea, they have won and you have lost and none of your rights have been violated. And for them to think that way at all is incredibly perverted and twisted, but this is how many of them think. If that was not true, then the National District Attorneys Association and the Solicitor General of the United States would not have taken that position, or taken the position that they did in the case of Pottawatomie County versus McGee, which was argued in the United States Supreme Court in November of 2009. So once again, if you have questions, if you want to make comments, if you can email me at strikelawyer@gmail.com. You can contact me on Twitter, which is @strikelawyer. You can put a comment up here on the blog. I'd be happy to deal with any questions that come in. But in the meantime, I do need help to get a petition filed in the United States District Court in Rochester. So there is a donate button up on the left or the right. I'm not sure which is which as I look here, but there is a donate button. And through PayPal, you can make a contribution, and that's where we're at. It is, I realize there are many worthy causes that probably come to your attention, but this is one, and I would appreciate any help that anyone can provide in correcting this gaping hole in the constitutional jurisprudence of the United States of America. So it is kind of a big problem, and I appreciate it.